Welcome to J Law classes. If you like these lectures, please click on like button given below. Your comment and each appreciation is motivation. Any suggestion will be an inspiration to improve and move ahead. The topic for today is foreign judgment as per provisions given under Section 13 and Section 14 of Civil Procedure Code 1908. To attempt this topic in any examination, as J Law classes recommend, always begin with introduction, then definition, the object, and the most important part of the topic when it is binding and when it is not binding. Then comes your presumptions as to foreign judgment mentioned under Section 14 of the Civil Procedure Code 1908. Then is the foreign award and then the execution of foreign judgment. Let's take up the first point, that is introduction. Foreign judgment means a judgment of a foreign court. In other words, a foreign judgment means an adjudication by a foreign court upon a matter before it. Thus, judgment delivered by courts in England, USA, France, Germany, etc. are foreign judgment. The judgment delivered by a foreign court of competent jurisdiction can be enforced by an Indian court and will operate as res judicata between the parties thereto, except in the cases mentioned in Section 13 of the Code. Let's move on to the second point, that is definitions. Subsection 5 of Section 2 says, foreign court means a court situate outside India and not established or continued by the authority of the central government. Subsection 6 of Section 2 says, foreign judgment means the judgment of a foreign court. Section 13 says, a foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title, except under the provisions of subsection A to subsection F of Section 13. Object. The judgment of a foreign court is enforced on the principle that where a court of competent jurisdiction has adjudicated upon a claim, a legal obligation arises to satisfy that claim. We have a case on this, Satya versus Teja Singh, AIR 1975, SC 105. Supreme Court has very well said that such a recognition is accorded not as an act of courtesy but on considerations of justice, equity, and good conscience. The most important part when it is binding, the Code of Civil Procedure provides that a foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title except subsection A to subsection F of section 13 of the code. Means there are 6 points that are considered where foreign judgment are not binding on Indian courts. When it is not binding, under section 13 of the Civil Procedure Code 1908, a foreign judgment is conclusive and will operate as a res judicata between the parties thereto, except in the cases mentioned in subsection A to F of section 13. This means that foreign judgment is not binding in cases mentioned under section 13A to section 13F of the Code 1908. Dicey rightly stated, a foreign judgment is conclusive as to any matter thereby adjudicated upon and cannot be impeached for any error, either of fact or law. In following 6 cases, a foreign judgment shall not be conclusive, meant that foreign judgment shall not be binding in following cases. First one, foreign judgment not by a competent court. Second, foreign judgment not on merits. Third, foreign judgment against international or Indian law. Foreign judgment opposed to natural justice. Foreign judgment obtained by fraud. And the last one, foreign judgment founded on breach of Indian law.
Okay, now let's cover these points in details. First point, subsection A of section 13 says the foreign judgment not by a competent court. It is a fundamental principle of law that the judgment or order passed by the court which has no jurisdiction is null and void. Thus, the judgment of the foreign court to be conclusive between the parties must be a judgment pronounced by a competent jurisdiction. Next, subsection B of section 13 says foreign judgment not on merits. To explain this, we take up a case over here, Narasimha Rao versus Venkata Lakshmi, 1991, 3 Supreme Court cases 451. In order to operate res judicata, a foreign judgment must have been given on merits of the case. A judgment is said to have been given on merits when, after taking evidence and after applying its mind regarding the truth and falsity of the plaintiff's case, the judge decides one way or the other. Thus, when the suit is dismissed for default for appearances of plaintiff or for non-production of document, even before the written statement was filed by the defendant, or when the decree was passed in consequence of default of defendants for furnishing securities or for refusing leave to defend, such all judgments are not on merits. Third point, subsection C of section 13 says the foreign judgment against international or Indian law. It says the judgment based upon an incorrect view of international law or a refusal to recognize the law of India is not a conclusive one. Here we again take the same case of Narasimha Rao versus Venkata Lakshmi, 1991, 3 Supreme Court cases 451. When a foreign judgment is founded on a jurisdiction or on a ground not recognized by the Indian law or the international law, it is a judgment which is in defense of law. Hence, it is not conclusive of the matter adjudicated therein and therefore unenforceable in this country. Basically, what it means to say is that कि अगर वो हमारे लॉ को रिकॉग्नाइज नहीं करता है कि भाई the decision has not been taken as per the law of India, Or on other hand, if the decision has been taken not as per the law of international law, that is not going to be enforceable in this country. मतलब कि उसको लागू नहीं किया जा सकता हमारी कंट्री में, और ऐसे केस को रीओपन किया जा सकता है. Now we come to the fourth point, subsection D of section 13, that is foreign judgment opposed to natural justice. It is essence of a judgment of a court that it must be obtained after due observance of the judicial process. That is, the court rendering the judgment must observe the minimum requirement of natural justice, which means that it must be composed of impartial persons, act fairly, without bias, and in good faith. It must give reasonable notice to the parties to the dispute and afford each party adequate opportunity of presenting his case. सो बेसिकली नेचुरल जस्टिस क्या होती है वो आपको एक्सप्लेन करना है इसमें, कि अगर वो नहीं दी गई है, इम्पार्शियल पर्सन नहीं थे जैसे, या फिर उनको नोटिस ही नहीं दिया गया था, या नोटिस दिया गया था तो बहुत शॉर्ट नोटिस दिया गया था. सो अगर ऐसे केसेस में अगर वो कोई फॉरेन कंट्री डिसीजन लेता है तो दैट इज नॉट गोइंग टू बी एप्लीकेबल इन इंडिया, और उसको अगेन वी कैन री ओपन द केस एंड रेस्ट जुडिकेटा विल नॉट बी एप्लीकेबल इन दिस केस. Now we come to the fifth point, subsection E of section 13, judgment which is obtained by fraud. Before we cover this, let's take some maxims. Fros et jus nuquam cohabitant, which means fraud and justice never dwell together. And the next one, fros et doles nimini petrognary tibent, which means that fraud and deceit ought to benefit none. Also, in the words of Lord Denning, which observed that no judgment of a court, no order of a minister can be allowed to stand if it has been obtained by fraud. So, the foreign judgment which is obtained by fraud, we take here again a case of Narasimha Rao versus Venkata Lakshmi, 1991, 3 Supreme Court cases, 451. In this case, a husband A obtained a decree of divorce against wife B from an American court on the ground that he was an American citizen. Okay. Then he remarried C. His first wife filed a case against both A and C for bigamy. A and C filed an application for discharge. The Supreme Court held that the decree of dissolution of marriage was without jurisdiction. क्यों अब यहाँ पर कहा गया है कि भाई ये jurisdiction नहीं थी? क्योंकि neither the marriage was solemnized nor the party last resided together in America. It was therefore unenforceable in India. So what basically happened that in this case, the husband convinced the American courts that they were married and citizen in America, and the divorce should be given by the American courts, and definitely the American courts on the fact of the case what was presented before them and took a decision, and divorce was granted. But when the case was reopened in India, they found that the decree has been obtained by fraud. They were not citizen of America when they got married, because they got married in India and they did not even resided together. ये भाई साहब खुद ही वहाँ पे अमेरिका में अकेले रह रहे थे और वहीं पर ही उन्होंने डिवोर्स फाइल करके डिवोर्स कर दिया. सो दिस इज़ ऑल्सो कॉमन प्रैक्टिस इन पंजाब ऑल्सो, कि इंडिया में शादी कर लेते हैं, पंजाब में किसी से भी शादी कर लेते हैं कि भाई मैं तुझे अब्रॉड ले जाऊँगा, और वहाँ पे जाके डिवोर्स फाइल कर देते हैं, और यहाँ पर उनको पता भी नहीं लगता है कि भाई साहब ने डिवोर्स फाइल करके डिवोर्स जीत भी लिया है और उन्होंने रीमैरिज भी कर ली है. ओवर हियर द फ्रॉड वाज प्रूव्ड एंड द केस ऑफ बिगैमी वाज charged, and it's a very good example that foreign judgment which is obtained on fraud is not going to be applicable in India. Sixth point, subsection F, subsection 13, which says the foreign judgment founded on breach of Indian law. It says when a foreign judgment is founded on breach of law in force in India, it would not be enforced. Again, to explain this, we take up a case of Satya versus Teja Singh. IR 1975 Supreme Court 105. The rules of private international law cannot be adopted mechanically and blindly. Every case which comes before an Indian court must be decided in accordance with Indian law. So the Supreme Court has given a very good guidelines over here that it should not be mechanically and blindly adopted whatever the international law has taken a decision, a judgment, and it has to be decided in accordance with the Indian law. Illustration. Let's take an example. A sues B in a foreign court. The suit is dismissed. The judgment will operate as bar to fresh suit by A against B in India on the same cause of action. Definitely. This means that res judicata will be applicable क्योंकि वो फॉरेन कोर्ट में डिसाइड कर लिया गया है एंड दैट हैज़ बीन डिसाइडेड बाय द competent court. The condition is this. In next example, we see that A sues B in a foreign court and obtains a degree. He then sues B again in India on that judgment, claiming that it was obtained by fraud in foreign court. Now over here, the B is not precluded from raising a plea that the judgment of the foreign court is not conclusive and does not operate as res judicata since it was obtained by fraud and not on merits.
Presumption as to foreign judgment under Section 14 of CPC 1908. The court shall presume upon the production of any document purporting to be a certified copy of a foreign judgment that such judgment was pronounced by a court of competent jurisdiction unless the contrary appears on the record or is proved. Foreign award. An award passed by a foreign arbitrator and enforceable in a country when it was made can be enforced in India. Now we come to the last point of this topic. Execution of foreign judgment. For execution of foreign judgment, a suit must be filed within 3 years from the date of the judgment, and a foreign judgment which is conclusive and does not fall within the mischief of any of the clauses, that is from A to F of section 13 of the code, may be enforced by taking out execution proceedings in India.
Thank you, Jigyasa Mehra, one of my students helping me lecture, and I will be involving more students to come forward and help me in my lectures, but they should have some nice ideas. Coming back to the topic, let's revise foreign judgment. Section 2, Part 5 defines foreign court, and Section 2, Part 6 define foreign judgment. Trick to learn these definitions. Definitions are given in Section 2, but which part of the definition it contains is like when you see the word foreign court, COURT, it's 5 words, and subsection 5 foreign court and subsection 6 foreign judgment. It's immediately after that. If you remember this, you will always remember which subsection it's contained in. Next is section 13, res judicata, applicable except in 6 conditions from A to F of section 13, which I've already covered. And next, section 14, presumption as to foreign judgment. Now, by now, students must be remembering like section 11 was res judicata, and section 12 was bar on further suit as per the rules contained therein, where the CPC is applicable. And to remember, it's very easy. Bara is what we call in Hindi 12 से बार याद रखना, तो ये आपको याद हो जाएगा कि 12 से बार है और नेक्स्ट ही फॉरेन जजमेंट शुरू हो जाती है, जिसमें सेक्शन 13 में बताया गया है कि फॉरेन जजमेंट इज बाइंडिंग बट इन 6 conditions given, the foreign judgment is not binding on Indian courts. Although the topic foreign judgment is over, but from competition point of view or for others for the sake of knowledge, let's cover the other parts and elements regarding foreign courts. Just to enhance your knowledge, we are covering the other parts. Section 29 speaks about service of foreign summons. We don't need to go into the details of that, but if a question arises whether the service of summon is done to foreign courts, yes, it is done. And under which provisions? Under Section 29 of Civil Procedure Code. Next come is Section 78 speaks about commissions issued by foreign courts. These are basically done for examination of witnesses. Next, Section 83 speaks about when aliens may sue. Yes, it's a very interesting question for some people who does not know about this, that even the alien enemies residing in India, with the permission of the central government, an alien friend, means both are covered, the alien enemy and alien friend, may sue in any court otherwise competent to try the suit as if they were citizens of India. But there is a rider to it. But alien enemies residing in India without such permission or residing in a foreign court shall not sue in any such court. There is very important explanation to section 83, which says that every person residing in a foreign court, the government of which is at war with India, मीन्स अगर कोई बाहरी देश इंडिया के साथ लड़ाई झगड़े में पड़ा हुआ है और वहाँ का उस देश का जो हमारे साथ लड़ाई में इन्वॉल्व है, विदाउट टेकिंग द नेम ऑफ द कंट्री, आई एम सेइंग इवन इफ सम नेबरिंग कंट्री इज in war with India and any citizen of that country is having a business or business ties or dealings with India, such person, for all the purposes under this section 83, be deemed as an alien enemy residing in a foreign country, which means he cannot sue under the given circumstances of section 83. Next, section 84, when foreign state may sue. A foreign state may sue in any competent court, provided the private right vested with the ruler of such state or in any office of such state is in public capacity. Next is again in serial order, section 85, that the government will appoint a person either to prosecute or defend on behalf of foreign rulers. Next is section 86. This is very important because there are international tie-ups and international embassies, and because of dealing with these countries, ambassadors and envoys are working in every country, and they are working in India as well. And Section 86 says that suit against foreign rulers, ambassadors, and envoys can be done. These are in exceptional cases, so please don't be confused when you read that ambassadors are protected from being sued. So, for your knowledge, you must know it that this section deals not only with ambassadors, envoy of a foreign state, a ruler of a foreign state, high commissioner of a Commonwealth country are all covered in this section 86. Next section is section 87. Foreign rulers may sue in the name of his state. There's also an exception to this rule that under 86, the consent of the central government may be taken that the ruler may be sued in the name of an agent or any other name. Section 87A, it defines the foreign state and the ruler. It says it has to be recognized by the central government.